We don't have
I'm
public
Jamie Hill,
speakers at the moment.
Chief of Staff
So
of the AG.
Senator Logan and I are going to bellow for the first part of
Again,
our
nice to
program on landlord-tenant rights. We are very appreciative of the staff of the Massachusetts Office of the Attorney General, now occupied by Andrea Joy Campbell, who is outstanding. These folks, however, work doggedly for whomever the Attorney General is. They are career attorneys in public service, and we are very grateful for their being here. I would like to recognize our select board member, two select board members, David Mills, who began his career in the Office of the Attorney General long before any couldn't resist. And we also have select board member Maureen Bernard over there. We have our housing authority members, including Lisa Silva, Carla King, am I missing anyone? And Cindy Dunn, the executive director, not only of Danvers, but Danvers, Middleton, and Rowley. So a great resource. Thank you for being here, Cindy. Eric Crane of our school committee. And I want to say thank you quickly to my staff, Chloe Mitchell. And also with the senator tonight is Sarah Cahill. The senator and I'll hand it over in a second, but I just have to say, one of the reasons we are here is because our offices have had a non-stop flow of eviction cases. People calling, but the two of us went to a meeting at the home of Barbara Merriman and some other folks. Barbara is in the back row. And without Barbara's invitation to meet with residents at Bradley, the former Danvers State Hospital, without that meeting, I don't think we would be having this meeting. And we do know that there's a terrible housing crisis. And we've been talking about a larger discussion focused on housing people. Thank you, DCAT, Greg Dolan, thank you. I can use the mic.
Yeah, you might drop that. Sorry about that.
Oh. But that means the flag might not stay.
We'll hold it up.
So. I just do want to say that we will do a larger conversation about housing and the housing shortage and how can we create more housing. But tonight is for people to understand your rights as tenants or as landlords. We might have some landlords with us tonight. I could not ask for a better partner to do this work than Senator Lovely. Without further ado, the Senator.
Thank you, Representative. You actually covered it. You covered it beautifully, and you know, housing is the #1 issue in our legislative offices. When people are calling, housing by far outpaces any other issue, and it's usually someone is at risk of losing housing. They've already lost housing, or they think that because they've been served with a notice, they have to be out tomorrow. So this is really wonderful to have the AG's office here tonight to really educate both landlords and tenants on what tenants and landlord rights are. So I'm going to stop right there and just say thank you and turn it right over to the AG's office. Thank you. Thank you.
Thank you so much, Senator Lovely, Representative Cairns. We really appreciate your invitation to join you here today and tonight in Danvers. Like you, our office has heard so much from residents across the Commonwealth with housing concerns. What you are hearing in your office echoes what we're hearing in ours, and we really appreciate the opportunity to join you this evening in this beautiful building, and hopefully what you learned tonight will equip all of you with more information about your rights. We also really look forward to hearing from you and doing a lot of listening as to what you've been experiencing. I'm Ann Landry, and I'm Chief of the Policy and Government Affairs Division in the Attorney General's Office, and I will turn it over to my colleagues to introduce themselves. Next up, Jamie Hogue.
Good evening, everyone. My name is Jamie Hogue. I'm honored to serve as the Chief of Staff to the Attorney General. Just want to thank you for being here tonight. Thank you for all you do for your communities. I want to particularly acknowledge my dear friend David Mills, who's already been recognized, but David and I go back about 25 years. And he's been a blessing in my life and just a big part of it. So I know he's a big part of this community, so I want to thank him for all of his service to Danvers and the people of Danvers. But I just want to thank you, each of you, for being here. We're your Attorney General. We represent you, and so whatever we can do to help you, we're here to listen and learn and provide helpful information. But this is just the first of a series of conversations we're willing to have with you. So this is not the only time we'll have a chance to have dialogue. But we'll pass around our business cards and our contact information at the end of this session, so you have ways to contact us and ask follow-up questions and just realize that we're here for you. So thank you very much. I'll turn it over to Bill.
Thanks, Jamie. My name is Bill O'Hearn. I'm the Chief of the Consumer Advocacy and Response Division at Attorney General Andrea Joy Campbell's office. I've had the privilege of serving the Attorney General's office for 11 years, and I've worked on housing issues that entire time. Starting in our Home Core program, which was our response to the mortgage foreclosure crisis back in 2011, and I've been with the AG's office since that time. And I'm going to be speaking to you tonight about landlord-tenant issues specifically, which is within the scope of my division, our Consumer Advocacy and Response Division. Look forward to talking to all of you.
Hi, everyone. My name is Lisa Sears, and I'm a Senior Policy Advisor in the Policy and Government Affairs Division. I just want to echo everybody and say thank you so much for coming out tonight, and we look forward to hearing from you.
Good evening, everyone. My name is Sharif, and I'm the Director of Outreach. We're in the Community Engagement Division. It's a pleasure to be here. It's always an honor to connect with people in various communities, and this is what we do, Emily and I, and I'm going to have her introduce herself. Thank you so much for being here.
Good evening. This is a very deep bench here from the Attorney General's office. My name is Emily Torres-Coning. I am the Chief of Community Engagement, and the number one thing that we would like to do tonight is listen and also present as much helpful information that we can. So without further ado, what we're planning to do is do actually a little bit of listening up front and give you actually an opportunity to share with us some of the things that you really wanted to share tonight. We would love this to be interactive, give you a chance to ask questions, and then after a few minutes of that, we're actually going to have Bill follow up with the presentation on landlord and tenant rights. And hopefully that answers a lot of some of the questions that you have as well. And then we can do questions and answers after that. Again, just to repeat what Jamie was saying, we are your government. We are here to serve you the best way that we can. We may not have all the answers for you tonight, but we'll be taking account of what you're sharing with us and trying to point to as many resources as possible. Please keep in mind that the Attorney General's office can inform people of the Commonwealth generally about their rights and obligations, but we actually can't represent individuals, and our attorneys can't provide legal advice. So just keep that in mind as we're having the discussion. That is something that we're not able to do. But again, we are trying to make sure that we come here today with as much information that we can share and resources that we can provide. All right, so before we get started taking questions, another thing we wanted to make sure to do was create a space of discussion. I know a lot of you have a lot to say or to ask of us. And so we and I usually facilitate community discussions. A little away from me, is it too much of a feedback? Okay, sorry. And so we actually have, I think, the green paper, which is on the table in the back, just some group agreements. So some group agreements to hold ourselves accountable to. These I'm sure are familiar for many, town meeting presentations that you usually have. And so Uma and I are just going to read them quick, and then we'll see if anybody wants to add to the list.
Thank you so much, Emily. So number one is when you speak, please state your name. And if you'd like to disclose where you live, that would be interesting for us to know so that we all can get to know each other. Number two, one person speaks at a time. Please pay attention to the person speaking to show respect. If you think you will forget any idea that comes to mind, please feel free to write it down. I'll pass it on to Emily.
Listen to and respect other points of view. We show empathy by listening to the concerns of others. Bless you. Ask questions to seek clarification when you don't understand the meaning of someone's comments. Everyone is encouraged to participate by sharing their concerns and experiences. And
Thank you. And finally, if you have already voiced your concern, let others have the opportunity to do theirs as well. No one or two individuals should dominate a conversation. Again, we are here to listen. We're really excited to be here, so let's use the opportunity to have an open dialogue, honest conversation, and know that we are here for you. Thank you.
Thank you both. As a former Brownie leader, we used the talking stick. And to this day, in my family, as 4 adults, we'll listen often to a meeting or a program and say, oh, needs to pass the talking stick. So I'm going to put one person on the spot a little bit. I hope that's okay. I'm thinking that we'll start with Barbara to kind of set the table on what's happened with Bradley, and we can bring the mic to you.
I used to be a junior high school teacher. I think I got big enough voice.
I think it's for
Oh, but we want the audio for the cable program. So do you mind? Or here, right here. You're good?
Good, okay.
All right. And I'm thinking 2 or 3 minutes. Tell them that you were a former California Planning Commission board member.
We used to limit these to 3 minutes when I was running a meeting in California, but anyway, I wanted to compliment, I live at Bradley Danvers, which used to be the former state mental hospital. So my daughter introduces me as, this is my mom, she lives in the nut house. Anyway, I want to compliment the owners in one way. The UDR has done a fabulous job renovating and upgrading and doing all kinds of spending tons of money. But they've also done some things that are a little on the not so nice side. For instance, they raised the rents anywhere from $200 to $1,000 last year a month. They are not now renewing leases because they want to renovate all of the apartments. So each month, 10 or 12 apartments don't get a new lease, and I'm one of those. But I've got another place to go, so no problem. But they are continuing to charge for open parking, which is new. They charge $60 or $65 a month for reserved parking. But open parking is $15 a month if you can find a place. They are charging now for the new package room, $8 a month for the postal service to deliver you a package. And if it's there for more than 3 days, you pay $3 a day to get it back. So those are, and there's some other things that they've done with water heaters outside that I'm going to let Melissa talk about. But there's a couple other things. They have a lot of sidewalks around the complex that have tripping hazards that haven't been fixed. That's a serious problem that somebody needs to address. I talked to Steve Latulip in the Town Building Commission, and he said that was beyond his scope. So I don't know whose scope that is. There are no safety locks on the windows above the second floor, and I understand in the state law says you have to have that to prevent kids from falling out. We don't have those. And UDR is in a lawsuit in Washington, D.C. because of the algorithms they have paid for to take care of their rent. They can raise the rent on this algorithm to, if they've got a 20 or 30% vacancy, it doesn't make any difference. They have this algorithm that shows how much the rents need to be raised for that. And the other thing they're doing brand new this year is Airbnb. We can sublet our apartments to Airbnb, but they get 20% of that. I think that's all I've got right now. So, somebody else want to talk? Melissa?
I was hoping Melissa, but, yeah, okay,
Sure,
so
I'm right here.
and then,
I can talk too.
Okay, my name is Melissa Putman. I also live at Bradley Danvers. To follow up on her points that she made with we were never charged parking. I've lived there since it was brand new. We were never charged to park in an unreserved spot. But they redid the parking lot and sprayed everything down all of a sudden I think, to pay for the money that they had to spend to do that. They'll put it back on us. We can only expect to receive packages at our primary address. That's where we live, so where else would we get a package? We were never, ever charged for packages before, but they just happened to have put in a new package locker system, which opened in October. So, we have a package charge. So all these things are being hit back on us. I have two questions that regard, we have a water bill. And I brought a page, whoever wants to take that when you leave. I recently signed my lease. And it's always been like, I put a hocus pocus formula for how they get the water rate. I've been to the town of Danvers. We do not get, supposedly, town of Danvers doesn't give us a water bill. Bradley or any other owner has given us a water bill. But the rate is way different than the town of Danvers. Obviously, higher. And they have installed in the past heaters in the utility closets. Our utility closets, for about 75% of the people in our complex, are outside on a deck. So they're obviously in a closet. I have pictures to bring as well that's uninsulated. There's no insulation on the pipes. There's no wrap on the heater. I have a nice picture of the big hole that went out the wall. So they had a massive amount of frozen pipes during the winter. And then one of the companies did not tell us, and they put little heaters in there.
Friendly.
Oops, sorry.
Yeah.
All right,
And there's no sound online.
Okay.
So maybe say that there's no sound online, and you keep that close to you.
Okay.
Okay, good.
Thank you. So there's no heater. They put heaters in, and then everybody's electric bill was like sky high. We're like, what happened? What happened? Well, they didn't tell us. So now they have built-in heaters, and I have gone to the town of Danvers in the past, and I have all the correspondence I had with a gentleman there named Mark Calio. I will drop off a copy. I've already given that to Sally and Joan a while back. But the letter that Mr. Calio wrote states the law, and they're supposed to provide working utilities. That shouldn't be on my electric bill because the closet's going to freeze. So I'll have those papers as well. So the only other thing just to be aware of is we put in new HVAC in most of the units in our complex. And early on, there was a tenant there that does HVAC work. And he called the town. They were not pulling any permits for any of the work done. And the people that were doing the work were mostly in unmarked vans, so there were no license numbers, no contractor numbers, no names of anything. So I know the town did do a stop work order, and I don't know what happened after that. But it's a continual flow of issues that we just can't seem to, all we really want to know is this legal? Can they charge us to park where we live? We just want some answers. That's all we're really asking for. So I thank you for your time. Are you going to bring it over to her?
Yeah, great. Great, thank you. Going this way. Hi. Speak right into this.
Hi, my name is Michelle Maurice. I too live at the UDR Danvers Apartments. I've been living there for about 8 or 9 years, and it has actually went through about 5 different companies. This recent company they have done a lot of renovations, but they've probably been the company that's been the hardest to deal with because they've done these, what they call renovictions, like Barbara has said. They've given people, and it's kind of luck of the draw, 60 days notice to move if they decide to renovate your apartment. And they've decided it's luck of the draw. You might be renovated, I might not be. And they give you 60 days notice, and so if they're going to renovate your apartment, you have 60 days to either move all your stuff out of the apartment and A, put it somewhere else and move into a hotel for a month, or B, take another apartment. Now, maybe Barbara is one person, but if you're a family, like I have children, and there are a lot of people who have children, it might be kind of hard to move your whole family into a hotel and put all your stuff into storage for a month. And what hotel is going to take a whole family for a month? Recently, when they've done one of these renovictions, one of the families who lived in the building next to me ended up being evicted because they did not want to go along with the renoviction, and they could not afford the rent increase. They had 3 children. Recently, they were told they were going to have to pay $600 more a month rent, whether they moved to a new apartment or whether they went along with the renoviction. They couldn't afford that rent increase. She said she was just trying to get by with the rent she was paying. She ended up moving into a hotel with her family, and she is still homeless. She told me. She's come by several times. She's asked a couple times, for one of the neighbors to pick up her mail, and she has nowhere to live with her 3 children. This is the position that people are being put in. There was another couple upstairs. They have 2 children. They, too, ended up homeless. They had 60 days to move. In the type of economy they have out there, it is very hard to move and find a place to put your family in with 60 days. A lot of times, if you go to court for something, a judge will keep continuing it. The UDR somehow is jumping over these hurdles and getting people out of these apartments with these kind of, I don't know how they're doing it, but threats or whatever they're doing. Maybe, I don't know whether they're just telling people they have to move and people are going along with it. But people are moving and having nowhere to move to, sometimes in the winter. Like I said, that family that ended up moving and ended up in the hotel, I actually saw them in my parking lot, and they were sleeping in their van one night, and that's the truth, and it was sad, because I called the police. I said, who's out there in the van? And she came out and told me, I have to sleep in my van some nights. I don't always have enough to pay for the hotel. And that was very sad to hear somebody say that to me. And she does work. And so does, her daughters. They work part-time jobs and go to college. So that's kind of sad to hear somebody tell you that. In the past, we pay for electric, we pay for all utilities. In the past, we had to pay for water, and I guess with the new leases, we do also. Sometimes my water bill would be as much as $180, $200, $300 a month. I was told by the town, it's private metering. It goes through a third-party company. I don't know how a little apartment's going to run me $300 a month for water. Some people who have houses don't pay $300 a month for water. I mean, it's not like I have a pool that's sitting on my little tiny patio, and I mean a tiny patio. So I think they're, pulling some strings and doing some things they shouldn't be doing there. So that's all I have to say. There are a lot of families where I live. There are a lot of people that are elderly and that are handicapped. In my building alone, there are 12 apartments. A lot of them were long-term. Out of the 12 apartments, there are only 5 people who've been there more than maybe 2 years. Everybody else has moved out because they have these renovictions, and some of them have had no place to go, and some have moved out of state. And that's just in my building alone. There's about 400 to 485. I think Barbara would know the exact number of apartments there. So that's all I have to say. And something needs to be done. Thank you.
Well done, thank you. Very painful, very troubling, disturbing things. You're having to write a lot, so I'll burn up in 10 seconds. Let your fingers rest a little bit. Are there folks here of any age who would like to speak I'm probably standing in the wrong, is there someone else from Bradley or any other apartment building where there are landlord-tenant issues and you're looking for clarity? Is there anyone here from Fairweather or Sophie? Okay, because those are frequent flyers in our offices. Yes.
So Jerry Halberstadt is
Oh,
online.
yes, sorry.
Fairweather. I don't know.
Perfect.
Opportunity, but Fairweather is represented by, Jerry lives at Fairweather. fair weather.
Yes, excellent. Okay, now, to make that happen. Oh, did you want to, while we're queuing up Jerry, Chloe, can you do some wizardry with a laptop over there or something? And then, yes, did you want to speak? I'll bring the microphone to you.
Hello, everyone. My name is Olympia Benitez. I'm from. Sorry. Oh, thank you. I'm from Bradley as well. And one of the things that I didn't really agree with Bradley is obviously like the rent evictions and a lot of things that they're charging for, like parking and all of that. And also like with the other things they did, like change like the locks and the locks that are like the I'm sorry, I'm not really good at, the smart locks, thank you. And those are like kind of like dangerous, like anybody could like, those malfunction a lot, and it's like we don't really get a say on to like if you want to like keep the other locks or not. And I have almost had like people like break in and there's like no security, and it's very like troubling, and they like upcharge for that stuff too. And also like for like thermostat, like they changed it to like, like a smart thermostat as well. And we pay for that stuff. And to get the heat to kick in for like 10 minutes while you're like freezing cold, it's just like unacceptable as well. And yeah, that's pretty much like my complaints. And there's like no security like anywhere, so like anything can happen at any time. And we pay so much to not even feel safe or secure in our community.
So I did want to underscore one point, which is it seems as though there are two sets of things happening. One is the rent evictions. That's a term I will not forget. The parking charges, the things like this. And then there's the unresponsiveness of Bradley or its property manager. And is that a separate company? Or does Bradley contract out the property management?
Bradley's the name, it is owned by UDR.
Okay, so UDR is a company, but the management of it is all under the Bradley umbrella. And you feel like they have not been responsive? Horrible, okay. Oh, yeah, they've blown us off, too.
Right, no, we've been in touch, both of our offices, with UDR, just to be able to start a conversation, just so we can understand zero response. It actually, we had sent a letter to their legal counsel, but acknowledged the letter, but then would not respond. So it's been difficult.
Senator, where are they based? Just
Where are they based? Colorado. Yep.
They also own 14 North. They own the property 14 North, and I believe that
14 North in Danvers. Yep, they own that.
North also, which some of the apartments there are based out of Danvers.
Okay. Do we have Jerry?
We do have Jerry?
Jerry, the sound should be working. I'm not sure if Jerry might have stepped away for a second.
Jerry Halberstadt, are you online? I know I saw him come on. He's muted.
He's there. Not sure if he's there.
Okay, he's off mute.
Oh, here we go.
Jerry, thank you. Jerry Halberstadt is the head of the Stop Bullying Coalition. We're working on, actually a position in the Attorney General's office to respond, an ombudsman to respond directly to tenants. And so, a tenant advocate, yes, thank you. Jerry, are you there?
Senator Lovely for working with us to develop legislation so that the Attorney General can have an office dedicated to looking into the most severe types of problems where the landlords don't do what they're legally required to do, which is to make sure that people can live in peace. So it's a problem that is statewide, and it's brutal. So I would just urge everyone to support the work of the senator and the representative, and to testify in the hearings that are coming up next week. We've had support from so many organizations and individuals, but every voice counts, and I'm so glad that people are having an opportunity to express themselves tonight, and for the Attorney General's office to have a chance to hear and respond. Thank you.
Thank you. Thank you, Jerry. Thank you for your advocacy. When I first heard the term, was it called elderly bullying? Elder abuse. No, elder abuse I knew. But I'd not heard the term bullying pertaining to older people in congregate settings. And now I have come to see and understand it. It is shocking. So Jerry has done yeoman's work to make that an issue that we focus on, and so has the senator who filed the original bullying prevention. Right. So tell us where that is.
So we actually did filed, Jerry and I wrote it, a bill a few sessions ago to come up with a commission. And it actually passed in its first session, and a commission met and came up with recommendations. And one of the recommendations is to have a tenant advocate in the Attorney General's office. So now we're working on, with the Stop Bullying Coalition, to do that, and to, just to continue so that tenants know what their rights are, landlords know what their rights are, so that we don't have people that are ending up in housing court. Usually, I've practiced in housing court. It's not my favorite. I don't practice law now, but it's not my favorite court to practice in, because you're usually seeing a landlord will have, especially a UDR, which is a very large corporation, will definitely have legal counsel, and a tenant typically does not. There are housing specialists, though, in the housing court who work very, very hard to be able to come up with a resolution before the matter has to go in front of a judge. But if you're in housing court, it's usually not good, and usually a tenant is finding themselves, particularly the tenant is finding themselves in a dire situation. So we just want to make sure, again, the point of tonight is to make sure that tenants and landlords know what their rights are. And so thank you, Jerry, for all that you do, and we'll continue to work on that with Representative Kearns.
Thank you, Senator. I would be remiss if I didn't point out Ted Spiliotis is with us, who served very long and admirably and well in this position as a state representative for the 13th Essex District. Yes, applause. Thank you for being here, Ted. Thank you. And also happy to be joined by Mike Swindell, Danvers Housing Authority, and Dee Dutrochet Joko. I can't believe I forgot your name, of the Human Rights and Inclusion Committee. So thank you for being here. There's often so much crossover in these issues, so it's important that we're all in the same room. I wanted to mention mediation. I think there's someone here who is a friend of Hannah Bowen's or works with Hannah Bowen in the... Wonderful. Could you give us a shorthand version? We have about, I'm going to say, 5 minutes till we move into the presentation and discussion. Not even 3 minutes? Okay, perfect.
you'll yield back, as they say.
Thank you. So I am from the Resolution Center. We're based out of Beverly at the Cummings Center. We offer free mediation services for landlord-tenant and tenant-tenant disputes in which there's a risk someone could lose their housing stability. Mediation can be in person or via Zoom, scheduled at a time convenient for all the people involved. Mediation is a voluntary, confidential process to talk through the issues between landlord-tenant or between neighbors, focused on finding potential solutions that everyone can live with and that meet everyone's needs. For cases where eviction is possible, a possible outcome, mediation can help at any stage, including before an eviction is filed or during the court process. Anyone who's interested in learning more can call our office in Beverly or book an appointment directly with our website for housing cases. We typically do a brief intake call with each person who's involved in the situation, and if all agree to participate in mediation, we schedule a session within 2 to 3 weeks. So if anybody has any questions, I'll be happy to answer them.
Could you say your website name or where does one find what's it called again?
Resolution Center.
The Resolution Center.
Our website is resolutionnorthshore.org. Our phone number, if anybody would like it, is 978-232-1212.
Thank you so much. Is there anyone online who would like to speak? Pamela? Are you good? Did you want to speak or no? You're good? Can you unmute? Okay. If you would like to say something, you can call 978-766-8661. Which is my phone. Okay. We'll come back, Pamela, if you'd like to say something, we'll come back, but at this point, I'm going to hand it back to, oh,
Yeah, she's typing. I'll see what she says.
okay.
I think she might be having some problems with her computer.
Do we have I overlooked anyone in person? Oh, Mrs. Swiniarski, yes, hi.
If I sound choked up, I am. John and I are actually a fun couple that went through the renovation eviction, and we decided to go back because we loved the apartment. Not that we loved the services or, except you couldn't get better maintenance men in the whole world. So I have to say that for UDR, the most amazing men. But a little background. So last year, our rent went up $400, which I tried to fight in every way possible. I even had them come and read the dates on the oven and our electrical stove, because we're in a handicap unit. I'm handicapped. And it was a year off from the year that would have made them old enough that they would have had to give us some credit in some way. So that didn't work. It didn't matter. I tried everything in the world. Would not agree to anything. They started at $700. We got them down to $400. This year, we're still back in the same handicap apartment. Our increase is $300. We got the charge back, even though we were handicapped, on our lease for the parking for $65. Another $15 was to drive onto the pavement. That one thrills me. I hadn't, the water charges renewed, even though we left there, stored our stuff, a majority of our stuff in a storage unit there, and came back. Now we have to pay for the water. It's kind of amazing. But the thing that upsets me the most, and I'm grateful in one sense it was done for us, but I'm very ungrateful for the number of people who went to the office and wanted to come back, and we were slipped a piece of paper saying what we would have to write down on the application in order to qualify for the apartment that we are in. Again, I'm grateful. We have the apartment back. Not happy about the increase, but life is, it is what it is. But I think of the other families that had to leave because they didn't know that. So how do you balance that, right? You feel, thank God, we're back. But when you're told a figure that isn't even close to what you make, it's pretty interesting. And my last one is really quickly. They decided to crack down on people who didn't get stickers in either reserved or non-reserved. So about a month ago, at 9 o'clock, I thought, this is very funny. Why is the whole building rumbling? Well, it was a tow truck and out front the corner of our house trying to pick up a car. Oh, okay. That's 9 o'clock p.m. 9:30 p.m. A different tow truck. He's picking up a car on the other side of the house. 10 o'clock, another tow truck. I'm like, okay, this has got to be a joke, right? They picked up a car further down. 10:30, now I'm furious because I figured I would, if I liked to go to bed, we have a corner unit, so no matter which way they came, all you felt was the vibration of the tow trucks. So I called the police, and he listened to me, and he said, I hate telling you this. And I said, well, what? He goes, we can't do a darn thing. It's private property. I said, are you kidding me? And he said, no. I said, boy, I guess I'm really stupid. I mean, I thought that kind of a thing would matter. But he said, I'm sorry, it doesn't matter. So.
Excuse me, could I add something? Yeah. One thing I'd like to point out is that they're Airbnb-ing some of these units, and they give those people parking passes, but yet, like, my teenage son had to go and get, because he has a little moped that doesn't work and go over 50 miles an hour because it takes up a parking pass. He had to actually go, and if you have an electrical bicycle, he had to get a parking pass for that. And if, like she was saying, they'll have tow trucks coming around to tow everybody's cars if they don't have any type of pass all hours of the night. But yet these people who come in Airbnb, who actually go to UDR and maybe get, I guess UDR does have some of the units, they Airbnb themselves. Because there are, sometimes I've noticed in my building, I've seen different people in and out lately since we've had empty units, and there have been furniture delivered and whatnot. Those people are okay. They won't have their cars towed, but yet, you know, it's kind of like a game with them, but yet you don't know when the tow trucks are going to come. They're there all hours of the night. Sometimes they're there 4 a.m., sometimes they're there, and it's kind of scary. And it's also scary because they don't have cameras. You don't know who these people are who are coming onto the property. They're not very good. Recently we had some young kids who ended up stealing the maintenance's go-karts and rammed into things. People come on the property and steal things. The security is very lacking there, but yet they charge these tremendous rents. Thank you.
lots to unpack, as they like to say in the world of social sciences, but there is a lot here. Who's getting towed? Are they allowed? Yes, there's, and after this comment, I'm on my way, sir, then we're going to shift to the part where you educate us a bit and perhaps address some of the issues that we're hearing about. Hi.
My name is Joe Lynch. I live in Building 12, and we had, just like everybody else, I think, a pretty good increase in our last lease. What I'm noticing now is that they're leasing the same units for $300 to $350 less than what we're paying. If I'm right, I think that they might be looking for another increase over what we're paying now. So I'm just throw that out. I don't know if there's anything at all we can do, if there's any requirement, a legal requirement that would mitigate that. Thank you.
Great. Thank you. I do appreciate the presence and the strong advocacy from our neighbors at Bradley, but there are other neighborhoods too, other building complexes. Would anyone else who's not a Bradley resident like to say something, bring up a concern? Okay, as long as we're not closing off. Yeah.
You have Pam's comment if you'd like to.
Oh, here we go.
Here you go.
Well done, Chloe. Pam Goodwin. In Worcester Housing Court, as the plaintiff, I was denied a jury, never given a housing specialist until about 4 months into the 6-month pro se sessions. That's a you question. To start off, because pro se.
Oh, does she has a question about that?
Herself, right?
Yeah, yes, exactly, yeah. Right. Pro se means that you represent yourself. And what was her question?
That she never did get.
Yep.
She never was given a housing specialist.
A housing specialist, and, well, I think this is a good time to pass this over to the Attorney General's office. So thank you.
You want me to take it?
Yes, we're going to have the presentation start, but I just wanted to say thank you again for everyone that shared what they shared, and we really appreciated your honesty in sharing your experiences. And so we're going to pass it on to Bill.
I was just gonna reiterate my thanks, and I'm gonna try to remember. It was Barbara, Olympia, Joe, Julie, and I'm forgetting someone. Sherry. So thank you so much for sharing your thoughts, and I'm sorry, Mrs. Mamie. Thank you, Mamie. Michelle. Thank you, Michelle.
Thank you. I'm going to go ahead and get started with the presentation in a second here. But first of all, I just wanted to thank everyone for sharing your experiences with us. One of the things we do in our Consumer Advocacy and Response Division is take complaints from members of the public against businesses, and that does help us inform the decisions we make at the Attorney General's office. And I hope my presentation will answer some of the questions you've laid out. It is not going to answer all of them. Some of the concerns you raise, such as raising the rent, is not something we necessarily have control over. But we'll go ahead and jump into the presentation. And if you have specific questions, we'll leave some time for some Q&A at the end.
Just 1 second.
No, sure.
The Teams meeting went down, so we're just gonna start up a new one so we can present.
Sure. Oh, yeah, absolutely.
Thank you.
Thanks. Is that yours?
While we're waiting, if anyone, please help yourself to a seltzer if you'd like to, stretch your legs, and then we'll get into the presentation from our friends at the AG's office. I really do appreciate your all being, done a lot of this.
No worries. Thanks for your patience.
Do you all have drinks?
I had one in the other room, which was lovely.
Want to get a few? I'll get a few.
Oh, I already drank a little bit from the other room. Oh, maybe I'll get some.
Thank you, Jamie.
I know the feeling. Oh, I know. I had last.
Whatever you want to
I'm just, yeah. I'm just like, I'll just take lots of alcohol. It helps.
I just got over mine like 2 years ago.
I feel like it's just gonna come, and I get these.
No, it comes.
And it's, I know, and then mine stays like forever. So I'm just gonna have it. Then I feel like nobody wants to stay. Oh no.
Oh, thank you. I love it too. I've had it for so long.
It should be here in like.
Like every time
I don't think I need the email. I'm in the Teams meeting.
Oh, you're in the team.
Yeah, he sent me the invite via Teams. I just need the screen up there.
I hear you say you have a daughter. You have a daughter?
I do.
How old?
A 2-year-old. Did I hear you say 2-year-old?
I have a 3-year-old.
Oh. Is that terrible?
She's gotten worse.
Okay.
But I've been bribing her every night with stick-on earrings, and it's been really working.
Emily and I were talking about how they like get worse.
I fight with her over clothes now. I'm like, this is too young to fight over clothes. I know. She goes in her room, closes the door, and says, I'm going to dress myself. Wow.
Not ready.
That's me. I think we're good.
Champagne.
Very fancy.
Make sure it's working. It is. Excellent. A little slow, but we can deal with that. All right. I think we're about ready to get started.
Great, okay, take it away.
Are folks online okay?
Yeah, I'm gonna get them up as quickly as I can.
All right. I'll go ahead and jump into the presentation since I know we want to get everybody out of here on time. Is that better? Yeah. How's that?
Much better.
All right. Thank you, everybody, for your patience while we had some technical difficulties. I'm going to go ahead and jump into the presentation while our online folks are still popping into the meeting, just so we can get everybody out of here on time and make sure we still have enough time for questions. Before I jump directly into the landlord, no worries, take your time. All right, we're back. For good this time. So before we jump into the landlord-tenant law, I just wanted to do a quick overview so everyone's clear on exactly what the role of the Attorney General's office is. So our office does work in at least 4 different ways. Our office works on investigations, We do law enforcement, enforcing the laws of the Commonwealth. We work to do prevention through community engagement events like this one, as well as providing educational materials, guides, things like that. And then we also do policy work here at the AG's office, working on legislation and helping to change the laws in a way that benefits the people of Massachusetts. We've got 4 locations throughout the state. We're in Boston, New Bedford, Springfield, and Worcester. I think the closest office to here is probably Boston, although Worcester's not too far off. So we're all over the state. You know, we have consumer hotlines, we accept walk-ins to our offices, and we're also out in the community, like events like tonight. Before I start talking about the landlord-tenant aspects of tonight's presentation, though, I do need to give you an important disclaimer. I am an attorney, but I am not your attorney. The information I'm going to be providing you tonight is general in nature by necessity, and it is not legal advice. If you find yourself in a situation where you need legal advice, you really should talk to your own attorney. I cannot give you information or advice or apply the law to the particular factual situations you're having right now, but we are going to talk later in this presentation about how to find legal information and how to get legal help. So how does it all work? Government joke. So let's start. The real basics of landlord-tenant law. You've got 2 types of tenancy. Tenancies based on a lease and tenancies at will. Most of you, Bradley Danvers, are probably more familiar with the tenancy based on a lease. That means you have a writing. It lasts for a specific amount of time. Does not have to be a year. You can have shorter leases than a full year. And critically, the rent stays the same throughout the entire course of the lease. I know a lot of people have been talking about rent fictions or raises in the rent. That should not be possible under a lease. A lease is a contract that obligates both the landlord and the tenant to the terms of the lease. However, when the lease ends, then the terms can be renegotiated. And that's, I think, what I've heard from a lot of folks here tonight. That differs from something called a tenancy at will. Tenancy at will, sometimes there's no written agreement at all, or it could be a written agreement, but it just doesn't specify like a date. It says this will continue month to month on the first of the month for a certain amount of time. That's also a tenancy at will. And that can last as long as the 2 parties are willing to do business with each other. And in a tenancy at will, unlike a tenancy at lease, your rent can change with just 30 days notice. There's some required terms in the lease: owner, personal responsible for maintenance, the person to whom the tenant can give copies of formal notices of complaints or court papers. So if you're looking for, should you find yourself in a situation where you need to take legal action against your landlord, you should be able to look to your lease to find out, where their legal address is for service of process and things like that. So what does a lease actually do? So it outlines the obligations of both the landlord and the tenant. The tenant needs to pay rent, follow the rules in the lease, and accept responsibility for any damage above normal wear and tear. The landlord, on the other hand, has to provide the apartment that is safe, that is clean, and that's in compliance with the state sanitary code. We're going to talk more about that one later. The other thing the landlord needs to do is to live up to any promises that they made in the lease or rental agreement. There's also some statutory promises, things like what's called a covenant of quiet enjoyment, lawyers would call that, but it means that the landlord can't unreasonably interfere with your ability to live in the property that they've rented to you. And that, I think, is something that we can talk a little bit about more, but it's certainly something that some of the issues you've raised tonight implicate. So what do you have to pay at the start of a tenancy? There are only 4 fees that are allowed to be charged by a landlord at the start of a tenancy: your first month's rent, your last month's rent, a security deposit, which cannot exceed a month's rent, and a lock change fee. That's it. That's by statute. Those are the only fees that the landlord is allowed to charge at the start of a new tenancy. Now, that is to rent the apartment. Questions do come up about amenities, and we talked about that a little bit tonight earlier. Amenities can be charged as long as it is not mandatory for the tenant. So that's, a situation where I think there was parking fees were talked about tonight. If you are obligated to pay for parking fees, whether you park or not, that might be concerning, right? But if you are renting the parking space and you are not obligated to pay for the parking space, I think that's something that would not be considered part of the rent. Want to talk a little bit about the security deposit law. Landlords are required to give a tenant a name, an address, a bank holding, the bank that's holding the security deposit, and the account number. Each year, they need to pay the tenant interest on the security deposit or let them deduct that amount from the rent payment. They need to give you a statement of condition which describes the condition of the apartment and any damage that exists at the time. And they have to return the security deposit plus interest within 30 days of your tenancy ending. So these are really important rights. Massachusetts has a very strong security deposit law. So keep those in mind for those who do end up moving out of the apartment, or when you move in, getting that statement of condition. Some questions and information. Should you consider renting? Does the rent cover utilities, and which utilities do they cover? Hopefully that is in your lease. If the lease does not require you to pay for those utilities, generally they are the landlord's obligation. So look to your lease for that. If amenities are present, what are the additional costs? They can't require you to pay an additional monthly fee on the property, like a parking, pool, workout room, but they could restrict access if you don't pay that fee, for example. If repairs are necessary, both parties, need to discuss whether the landlord's going to make the repairs before you move in. So if there's any damage to the property, when you're viewing it, that should be discussed before moving into the property. Similar to the rental agreement, the lease or rental agreement needs to include a list of all repairs that the landlord agrees to make during the tenancy, and it should also note if any major appliances are included in the tenancy or not, like a washing machine, etc. We often get a lot of questions about pets. So does the landlord allow tenants to keep pets in the rental property? Will they require a tenant to pay a higher than advertised monthly rent? So this one's tricky. They cannot charge a pet fee. They can charge a higher rent if you have a pet. So that can cause a little bit of confusion. But it is not a one-time pet fee, because again, there's only 4 things they can charge at the start of a tenancy. Pet fee is not one of them. So will the landlord require a tenant to pay a higher than advertised monthly rent to keep a pet? That's got to be in the lease as well. If you have a service animal, that is not a pet. You should be very clear about that. That is not a pet if you have a service animal. If you have any problems with, the landlord not or failing to accommodate your service animal, that's something I would direct you to our Attorney General's Office Civil Rights Division. Just like our division in CARD, where we handle consumer issues, they take complaints about civil rights violations. All right.
I just want to stop you. Mamie, I know you're trying to take down the number. Did you get it? Did you get the number, Mamie? I know you were trying to take it down. So I saw you writing furiously, so I want to make sure you skipped the slide and you didn't get it. So
good call. Thanks, Jamie. I appreciate that. All right, so we talked about the obligations of the landlord a couple slides back, and one of them was that they have to maintain the apartment in compliance with the state sanitary code. So what does that mean? Well, the sanitary code requires the place to be habitable, meaning comfortable and clean enough for a person to live safely. If a sanitary code violation isn't addressed by the landlord, the tenant can request an official to inspect the unit. That would be usually the Board of Health of their municipality. If the landlord still fails to fix the problem, you may be able to withhold a portion of the rent or move out and break your lease. That's a pretty serious step. That's the situation where we would strongly encourage you to talk to an attorney or get legal information before taking that step. We also want to flag that there were a bunch of recent changes in April of this year to the state's sanitary code. They cover topics like pests, moisture, some new requirements regarding appliances in the kitchen, heating, and landlord's obligations to make repairs, and critically, the landlord's obligation to actually respond to requests. That's now built directly into the state sanitary code. The landlord's not only required to maintain a point of contact, they are required to be responsive through that point of contact. That is a sanitary code issue now. So if you are having issues with landlords not responding to sanitary code violations and ignoring your requests, that is something that can be followed up with your local Board of Health. Some specific winter considerations. Landlords are responsible to keep the heat at 68 degrees, 7 a.m. to 11 p.m. A minimum 68. I believe that's supposed to be maximum 68, minimum 64. And then a functioning heating and hot water system, snow and ice removal from entryways used by multiple tenants. So if you have common walkways, that is the landlord's responsibility, not yours. The tenant is required to pay for the heating unless the lease says otherwise. Shouldn't be billed for heating in common areas. That's a common one that we get complaints about. The landlord should not be charging you for the heating of common areas. If you have any specific questions about snow or ice removal, that can actually be subject to local ordinance, and it can vary significantly by town to town. So you may want to check in with Danvers about what their specific snow and ice removal requirements are. Okay, so how do you address these conditions, right? I've laid out a lot of responsibilities for the landlord. So what do you actually do if you're having a problem? And this is probably the most important thing, if you remember from my presentation tonight. You need to write to your landlord, not call them, not talk to them in the hallway, not walk up to them. You need to write to them. The reason you need to write to them is because the law protects you from retaliation for reporting conditions to your landlord in writing. Does not protect you from things you just say to them in the hallway necessarily. You cannot prove a retaliation case based on things if you don't have a writing. This is a really common trap tenants can fall into. They start reporting conditions. They're saying, you know, oh, the landlord's retaliating against me because I've been reporting all these problems with my unit. Okay, well, how did you report them and when? Oh, well, I don't know. I don't remember. I called or whatever. That's not the kind of evidence you would need to prove a retaliation case, which is very important. You need to write it down if you're going to be contacting the landlord about sanitary code violations. Also report to your local Board of Health. That will get a writing in place. The Board of Health, if they contact the landlord, they will also provide a writing. Still encourage you to do your own writing to the landlord. And if that still doesn't work to fix the sanitary code violations, that's when it's time to get legal help. We encourage folks to go to masslegalhelp.org. They have a fantastic page on housing problems. This is a site that's put together, I believe, by the Massachusetts Legal Assistance Corporation and all of the legal services organizations in the state. They have some great resources.
The font is hard to read.
Can I highlight it? I cannot highlight it right now. It is masslegalhelp.org. Everything after that you'll find on the page. It just says housing/problems. That's the direct link to the page. But it's a great page with a lot of resources, including a button where you can find legal help if you need it, and information about all the court resource centers, which is a great place to find help from things like Lawyer for the Day programs, should you need to go into housing court, you know, if you have an issue with your landlord or you're being evicted.
They should, yeah. Yeah, if you have the handout, you should be able to get the website there as well.
So one of the most common questions we get is, okay, so my landlord is not repairing this thing, or I'm having this dispute with my landlord. Can I withhold my rent? There are certain situations where you can withhold your rent if the landlord is failing to maintain the dwelling in a habitable condition. You can withhold, and this is important, a portion of the rent from the date the landlord had noticed that there was a breach of the warranty of habitability. Okay, so legal terms. Breach of the warranty of habitability, what are we talking about there? That's the landlord's obligation to keep the apartment in a safe and habitable condition for you to live in. So say, for example, your heat goes out. You can't withhold your rent yet. You haven't notified the landlord. You can withhold a portion of the rent from the time in which the landlord had notice of the breach. Again, we're getting into territory here where if this happens to you, get legal help. But just want to throw that out there, what we're talking about. You also have the right to make your own repairs in certain situations where there's conditions endanger your health. You've notified the landlord in writing, and the landlord then has 5 days to begin or contract for repairs. If they fail to do so, that's when you can withhold rent to make your own repairs. If you do that, you need to keep all of your receipts. The costs have to be reasonable. The landlord will absolutely dispute, if what the repairs you make are more, they're going to be charged for it. And you cannot deduct any more than 4 months of future rent to do any kind of repairs under that particular provision. Oftentimes, we're talking about heat here, furnaces and heat. My understanding of the issue with the heating closets and things like that. If there are repairs or pipes freezing or things like that, those are situations where, this may apply, but again, would strongly encourage you to get some specific legal advice before doing something like withholding rent if you were in a, frozen pipes situation. Oh, you want me to lean in a little bit more?
Why don't you use 2 microphones? Use mine too.
Sure, I can lean in and I can also speak up. All right, so we talked about making your own repairs. I also wanted to flag at this point in the presentation the low income home energy assistance program, commonly known as fuel assistance, which provides eligible households with help in paying portions of their winter heating bills. Application process on that started on October 1st for this year, and you can find more information about that through the mass.gov, and if anyone wants a copy of that, the link will be in the copy of the presentation. I can also help you find the website. Also want to mention briefly rent relief. There had been a lot of other programs available prior to this year related to rent relief. Currently, RAFT is the state's main rental program, which provides up to $7,000 per household. It can help with things like past due rent, future rent, utility bills, moving costs, and furniture. Should you find yourself in a situation where you do have to move out, that is a situation where RAFT might be able to help you, helping you do the first month's rent or moving costs associated with getting into a new place. It is income-based, it's 50% or 60% AMI, but it is there to help you if you find yourself in a situation where you need to help stabilize your housing or if you're facing an eviction. A quick note about subletting. This is something that does come up occasionally for folks who may be struggling to pay the rent. The idea of taking a roommate or something like that to help you defer some of the costs of your unit. That can bring certain risks with it. It's very important that you understand, you have an understanding with the person from whom you're renting, who the tenant in charge is, and if you are subletting from another person, that you understand that they are the tenant in charge and not necessarily the landlord. Those are, legally speaking, those are two different things. You want to make sure you have the landlord's name and contact information in case you need it. So don't just get the name of the person who's renting you the unit. You want to make sure you have the real landlord's name. And if you do make any payments to the tenant in charge, you always want to get a receipt for payments. And if you qualify for rental assistance, the benefits will go directly to the landlord, not to the tenant in charge. So if you are applying for rent, for RAFT, for example, you are going to need to work with the landlord and not necessarily the tenant in charge who you're renting from. I mentioned this earlier, but it's worth repeating. Your landlord cannot evict you for exercising your legal rights. Retaliation against tenants is illegal in Massachusetts. So how does summary process evictions work? So we're getting into talking about evictions now. First, the landlord needs to give you a 14-day or 30-day notice to quit. Depends on the type of eviction. That starts the court process, or that starts the landlord's eviction process. Once that time expires, the landlord will go to the court and they will file a civil complaint against you. That's the point at which you're going to have a record in housing court. And that's an important thing to consider. We do see cases, and there are landlords that screen tenants based on housing court records. So that is a really important consideration when you're working with your landlord on potentially being evicted. That's the point in the process where things take a pretty serious turn. The landlord still cannot evict you. So the 30-day notice has come and gone. They've filed a civil suit. That's the important date you need to know for the purpose of responding to the lawsuit. The landlord, you have certain rights in the lawsuit that the landlord is bringing against you that will be waived if you don't immediately act. Most importantly, you have the right to answer the landlord's complaint for eviction. So for example, if they're saying you didn't pay the rent, you could respond, you did pay the rent, or I paid some of the rent but withheld the rest because of the conditions in the apartment, things like that. You can lose those rights though if you don't respond, if you don't show up for court. You may also have the right to bring what's called a counterclaim, to say that, well, okay, maybe you have the right to evict me here, but I have a counterclaim against you. For example, you are retaliating against me because I'm raising my concerns about my habitable conditions here, right? So those are the rights that you have in the eviction process. If you're going to exercise those rights, it is really important to get good legal information, talk to an attorney, but it is very important that you respond and show up for court. All right. The other thing we want to talk about when we get into talking about eviction and tenancy in general is that housing discrimination, of course, is against the law in Massachusetts. It's unlawful to deny someone housing because of their race, their color, their national origin, ancestry, gender, marital status, religion, age, sexual orientation, gender identity or expression, military background, or disability. So if you do find yourself in a situation where you feel your landlord is discriminating against you on the basis of one of these protected classes, first of all, we do have a civil rights division at the Attorney General's office. You can also get legal help through masslegalhelp.org, which I pointed out earlier. So one of the other types of discrimination which people would often don't recognize is that your landlord can't discriminate against you for receiving financial help either. So they can't discriminate against you because of getting government benefits, such as RAFT, or refusing to fill out a portion of a RAFT application. If they do so, they could be violating Massachusetts law. Again, to report discrimination, contact our Civil Rights Division. So that covers the basics. I would like to open it up for questions in a minute, and I will leave up some of the resources that we have available at our office. We do have an Attorney General's Guide to Landlord-Tenant Law, and we also have multilingual resources. So our complaint forms and other information are available in multiple languages through our website. One final note, a couple places to find help. If you have a problem with housing conditions, Board of Health, if you're having a problem with rental assistance, the Department of Housing and Community Development, they have a central rental assistance application. If you need eviction help, that's when you go to legal aid. And if you need legal assistance, masslegalhelp.org, which also contains a link to the Massachusetts Bar Association Lawyer Referral Service. And that's our consumer hotline. So let's go ahead and open it up for Q&A. Yes.
When it says you can't discriminate based on income, one of the ways places do discriminate is if you get some kind of housing and the rent is over the amount the housing pays, and they purposely put it above the amount the RAF pays, above the amount the housing pays, and they purposely put it like that just so they don't have to accept people with housing. A lot of places do that, and so that's one thing I want to point out. A lot of the different corporations do that. They'll put something over the amount it pays, Or they'll say that you have to make 3 times the amount of money. If you have to make 3 times the amount of money, right off the bat, that gets rid of single parents. If you have to get a 3-bedroom, if you have to get a 2-bedroom, obviously, if you have children, that's going to put you over the, hey, you have to make 3 times the amount of the rent. That even if you're trying to make up for it with, say, child support, or if you're trying to make up for it with housing, that's going to throw you over, okay, you can't make up that 3 times the amount. You can say, hey, I'm going to make up for it with, say, housing, or I'm going to make up for it with child support. But they'll say, no, you have to make an income that's 3 times the amount of rent. So I just wanted to point that out, that a lot of these corporations kind of get around it by saying you have to make 3 times, including UDR. A lot of the people who they've done these renovictions for, when they come back and try to apply, like this family that ended up homeless, they were told they weren't making 3 times the amount of rent because she worked as a nurse's aide. And I just wanted to point that out.
Thank you.
Yeah, thank you for that. One of the things I did want to point out is for situations, if you do find yourself in a situation like that, or like some of the situations that were described earlier, we do take consumer complaints at the Attorney General's office as well as civil rights complaints, as we discussed. And we do have a free consumer advocacy service that we provide in response to those complaints. The service is voluntary. It's voluntary for you, and it's voluntary for the landlord as well. We can't force the landlord to reach a particular agreement, but we do get a lot of success. We get about 400, 500 complaints a week, on a whole range of consumer issues, not just landlord-tenant law. But we'll, get it assigned to a mediator either at our office or at one of our local consumer program partners, and we'll contact the landlord, and we'll try to help you reach an agreement with the landlord. And particularly in a situation like the one you described, we may be able to get to the bottom of what's going on. Is it a DTI requirement, a debt to income ratio requirement for the particular state program that they think or may be misinterpreting? That's not uncommon for landlords to misinterpret or perhaps advantageously misinterpret a program's requirements, and we can try to help clear up situations like that. Those are the kinds of cases where mediation is really critical to getting a positive resolution. And those are through our website, and is the best way. You can also call our consumer hotline, and we can mail you a complaint form.
I just had a matter of curiosity. When we went the day before we were coming back to the apartment and moving back in, and they refused us access to see the apartment the day before. Can they do that?
So this is where I have to just remind you, I can't give legal advice with respect to particular situations. In terms of if you had a lease, the landlord is not allowed to lock you out. So I'm not quite sure I understand if that's the situation that was going on, but if you did have a lease and they did not let you into the unit you were renting, we would consider that a lockout in violation of the lease.
But they tell you you don't have a lease, but you signed a lease in September, and I've come back in November. And they will literally in the office told us, you don't have a lease till the day that you move in, but yet the lease says September 23rd, but yet they refused us entry before November 25th.
Yeah, let's talk and see if we that might be appropriate for like something like a consumer complaint for our office to see exactly what was going on there. Because certainly if you're and again speaking generally here, but if you're renting a property and you're paying the rent, that's your unit. Like you have the right to occupy that unit. That's what a lease means.
We listed, thanks Mimi, sorry Barbara, 1 second before I jump in, I should jump in. We listed the number here for you to call, but we're gonna get your numbers before we leave and have someone call you. that's how it should work. We should be calling you, not you having to go through the problem of calling us. So we'll get your number, and we'll reach out to you. One of our consumer specialists and Bill's wonderful team will call you directly. So
Thanks,
don't worry about taking down that number as we flip through the
Yeah.
slides.
Thanks, Jamie.
You gave us 4 things they could charge you at the beginning of your lease, correct? First month, last month, security deposit, and lock change, right?
That's correct.
Can they charge an application fee of $550 and $1,400 for half of a month's rent? That's what I got charged.
It's not one of the 4 things in the statute. So here's what a lot of landlords do. They may consider charging a broker or application fee, because if you go through a real estate broker, brokers are allowed to charge a fee. If the landlord is the one charging the fee, that's a different situation, right? So in that situation, I think you would want to talk to an attorney about what your rights would be and how to advocate for those rights. Certainly, one situation, maybe that the landlord you might be able to resolve it through mediation or through a complaint. You could point it out. You could print out a copy of the statute, bring it to the landlord, and say, "Hey, look, this is the statute. These are my rights. This particular application fee you're charging me is not one of them." This particular issue regarding application fees, I think, has gotten a lot of public attention recently. I think you may have seen it in the news. So, it's a hot topic, and it's certainly one where you would be, you should advocate for your rights in that situation.
I've been there 9 years almost, and I have to go to a new apartment now because they're renovating my old apartment. And so now I have an application fee for the new apartment after 9 years. And half of a month's rent, $1,400. So.
I paid that too.
Yeah, that's what they're doing to everybody.
I've been 8 years.
In that case, sorry, I know you can't speak to the particulars, but at what point, thank you.
Sorry, with like 30 seconds left, but at what point does it become a class action? You got 400 units, I think, at Bradley. How many? 440 units. Potentially, these types of charges that are not allowed are accumulating for all these people. At what point does that?
So I should be clear, the landlord would not agree that that's illegal, right? And so, they will make an argument that the statute is vague or the statute is unclear, or that some authority exists out there that allows them to charge this fee. And that's why I'm being very careful about saying, when it applies to your situation, I can't say that's illegal. I'm not a judge, and your case isn't before my court. So that's a really, it's a difficult situation, and whenever you're in a situation where you need to, fight for your rights in court, there are real financial risks to doing so. Not just the cost of the attorney, but the risks of losing that case. And cases can be lost for all kinds of reasons that have nothing to do with the underlying dispute. So I really